Hello and welcome. This is once again the Disability Law Show. I am John Scholes. Beside me, Sivan Tumarkin, co-founding partner, Samfiru Tumarkin LLP, the most positively reviewed law firm in the country, dealing in Ontario and Alberta and BC as well. You can reach out across, and you can also catch our radio show, by the way. Disabilityrights.ca is the firm website. There's a media tab. Do radio shows pretty much all across the country. You can catch those in addition to this TV show as well. But reaching out beyond that, 1-855-821-5900, help@disabilityrights.ca. We'll give you some more websites and other ways to reach out to Sivan and his team here in just a bit. On the show today, 3 things you should always do when dealing with your disability insurance adjuster. This can be one heck of a minefield to traverse. You do not want to do this alone. You don't want to do it inexperienced. You want experience on your side. The way to do that is Sivan's team and get the firm helping you. Might be a denial one day. Could be for you. Could be a family member or otherwise. Do not try to go it alone. It is a David and Goliath situation. Even though David won that battle, you want to win yours as well. How do you do that? You reached out. We'll get to that here in just a bit, pal. But a week that was, the case you're working on, what do you say?
Ton of people I've spoken to this week, John. Let me select one which I really made me upset, like I often get with insurance companies. Look, I've been doing this for a very long time. I've been dealing with virtually every insurance company in the country, as has my team. And I've also worked on the defense side as an insurance lawyer before we started doing this for individuals. Now we represent only people against insurance companies. This was an interesting lady that I spoke with, a 32-year-old lady who works in an automobile manufacturing plant. And she makes about $45,000 a year. She has cancer, recurrent cancer, breast cancer. So she's a survivor and she's going through it again. She had chemo treatments, she had radiations, she had a whole gamut of drugs. She also has 2 young kids at home. And she has an oncologist, a family doctor, a pain specialist. So she has a lot of people around her who are supporting her medically, psychologically, and you know, in every which way. She's been on long-term disability for almost 2 years. Okay. And you know where I'm going with this. Oh, yeah. The 2-year mark, right? The 2-year mark. So she gets a letter from her adjuster, the insurance company adjuster. And the adjuster says, you know, remember that assessment you went to 3 months ago at that doctor that we sent you to? Well, that doctor has now given us a report that says that, you should be okay to go back to work, you know, in the next few months. They gave her a deadline, or not deadline, but a date. We think you're okay. We think that despite all the chemo, despite everything, you should be okay. You can just imagine the shock that she was in, her husband was in, her doctors were in. What are these adjusters doing? It's a crazy situation. She's in no position. And I spoke with her by video phone, actually, with her and her husband. I can tell you, she does not look ready to, forget about going to work, to just go outside to get the mail. And so it's crazy to me to think how these adjusters think and how these insurance companies think. Now, here's the thing. She actually was able to get a copy of the report from the doctor that she saw, the insurance company doctor, which is unusual, by the way, because insurance companies usually keep those reports close to their chest. Well, guess what? This assessor that saw her is a family doctor, a family practitioner that the insurance company hired. He's not an oncologist. He's not a specialist. So just imagine what her treating oncologist thought when he saw this report. He was livid. And he actually wrote a very aggressive letter back to the insurance company. So the reason I'm saying this is because insurance companies will use whatever excuse they can to cut people off. And of course, I told her, look, you have a case 100%. The fact that your benefits haven't ended yet, that they're ending in a month and a half, doesn't mean we can't take action right now. And we need to take action right now. We need to inform the insurance company we're starting a legal claim right now. Trust me, John, this is one of those cases. We're going to settle that case. We're going to resolve that case lightning speed, because the insurance company, once this claim gets in the hands of a more senior adjuster and a lawyer for the insurance company, they're going to back off faster than you can, you know, blink. It's crazy. And the thing is, it's not an uncommon circumstance. Insurance companies cut people off and deny claims all the time for nonsense, for no reason. You need to stand up for your rights, and that's what we're here to do. So that was something that happened this week that I was just livid about, but I thought people should know that even in these kinds of crazy cases where it's obvious the person cannot work, insurance companies will still do the unthinkable and cut people off.
Well, I mean, you mentioned the 2-year mark. We both kind of grinned at each other because that's, you know what's coming at that point, as you said. Explain a little more about that. What does that 2-year mark mean?
Under most LTD policies, and remember, we're not talking about workers' compensation or government disability. We're talking about specifically long-term disability that you have coverage for, either because you bought a policy privately or you have it through work benefits. And under most policies, not all, but most policies, for the first 2 years, you can get LTD if you are unable to complete or perform the essential tasks of your own occupation. It's called the own occupation test. Beyond the 2-year mark, the test changes. It changes to any occupation, but not just any occupation for which you are suited for by training, education, or experience. And typically when we look at that, we try to figure out if you can earn 60-65% of your pre-disability salary. If you can get a job at that 2-year mark that pays you around what your LTD is paying you, well then the LTD insurer may be correct in stopping your benefits. Maybe, not always. But in most cases you can't. For example, if you're depressed, if you have cancer, you can't do any other job that pays you anything because you are still disabled pretty much completely from doing any other type of work. In those cases, insurance companies still try to use any excuse they can to cut people off. And they characterize it sometimes as, oh, it's a 2-year policy. You only have benefits for 2 years. I got people calling me saying, I got only benefits for 2 years. Is that how it's supposed to be? No, it's not. It's not. The insurance company hasn't explained properly that if you qualify beyond the 2-year mark, meaning you cannot perform any occupation where you can get paid 60-65% of your pre-disability income, you should continue to get benefits. So my point is, that's how this test is. That's that 2-year mark. We see a ton of people getting cut off around that time frame, unjustly, unfairly, illegally, and we help these people get the money from the insurance company beyond the 2-year mark.
On previous shows, we've also talked about this concept of totally disabled and what most people think it is to actually what it means. Break that down for me.
Totally disabled is the verbiage, it's the phrase or the criteria you have to meet under an LTD policy to qualify for LTD. So when you look at the LTD policy or you look at the letter from the insurance company, they'll refer to total disability or totally disabled. And so when you think about that, totally disabled, I mean, I'm thinking brain dead, I'm thinking coma, I'm thinking just catastrophic injuries. That's not what it means. Not in LTD speak. It's confusing language. Yep. I think intentionally, purposefully, okay? I can't get into their heads, but I can tell you, it confuses people out there. It confuses doctors out there who call me and say, my patient is not totally disabled. And then I say, but can they work? No, they can't work. But they're not totally disabled. No. Under the LTD policy, total disability simply means you cannot perform the essential tasks of your own occupation for the first 2 years or any occupation for which you're suited for after the 2-year mark. So it's important to understand that that phrase or that concept of total disability has a different meaning than what you as a layperson or the doctor may conceive it to be. It's a much lower threshold to meet.
PocketEmploymentLawyer.ca. That's a website. Sure it is. Why am I bringing it up? Because it applies to you. It applies to this show. It applies to disability as well because there's a section under disability law under the Pocket Employment Lawyer website. Break it down a bit for me, pal.
Yeah, Pocket Employment Lawyer, of course, we have employment lawyers. We do employment law at the firm, and we do long-term disability law. Those are the 2 areas. And so we created this free website, Pocket Employment Lawyer, to allow people to go on it and to get free and quick answers about their employment situation. If you have a question about your termination or constructive dismissal, just go in there without actually contacting us even, and you will get a customized answer. But guess what? It's not just for employment issues, it's also for disability issues. Because oftentimes we have individuals contacting us who have issues with their long-term disability insurer as well as their employer, or sometimes just with their long-term disability insurer. And so we created a website that basically addresses both. And again, if you don't want to contact us, just go there, you'll get the right answers quickly and efficiently. If you want to contact us afterwards, click a button and the website will make the connection. But it's an amazing tool, John. It's better than Dr. Google. It's better than just Googling your information, which you're going to get probably wrong information, U.S. Type of information, which is not applicable to our laws. Phenomenal. Pocket Employment Lawyer. It's been used thousands of times across the country.
You want to reach out by email as well, help@disabilityrights.ca. I mentioned that off the top of the show. Want to get to our first one before we go to a break. Sivan, this is from Arthur. Says, I've been struggling with depression and anxiety since my son died last year of cancer. I also had a heart attack 6 months ago and haven't worked as an account executive since. The insurance company initially denied my LTD claim because they said my job was sedentary and I could still work. Should I appeal?
No, Arthur. First of all, I'm really, really sorry for your loss. I can't even comprehend the loss here, John. But it's even, I mean, it's just the amplification of what the insurance company is saying here. That because he's in a sedentary type job, he should be able to work. What does that have to do with what he's dealing with? You know, with depression, with everything else? No. Arthur, you have a case here, you should not appeal. These appeals, when the insurance company says to you, you can appeal a denial or you can appeal a cutoff, we're gonna cut you off, we're gonna deny your claim, and at the end of that letter there is 1 or 2 paragraphs that say, by the way, you can appeal the decision. What they're asking you to do, or they're telling you can do, is re-ask the exact same people who denied you in the first place to approve you. Why would they? Why would they? Now, I'm not going to say, like some of my colleagues, you know, that appeals never work. You know, that's their experience maybe. That's not the point. The point is that why would you put yourself, your fate, the fate of your claim, in the hands of the same people who denied you in the first place? It makes no sense. They have no incentive to approve your claim, no matter how much you give them by way of new documentation. So what is the alternative? This is where we come in. We use the power of the law. Insurance companies are not above the law. In fact, they're afraid of the law because they understand that if they don't come to the table and resolve the case the way they ought to have dealt with it at the beginning, which is reasonably, which is empathetically, you know, which is in accordance with the fiduciary duties that they owe individuals, because insurance companies have a fiduciary duty to you, the insured person, to deal with you fairly and justly. They understand that if this thing goes all the way to court to a judge, which, by the way, these things almost never do. Forget about what you watch on American TV. LTD cases almost never go to court across Canada because insurance companies are scared. It's too expensive for them to fight these claims. And there have been quite a few cases across the country where not only have people won these cases, but judges have brought down the hammer on insurance companies and awarded additional damages against the insurance company. It's called punitive damages. Google it. Punitive, aggravated damages. Insurance companies do not want to get into a courtroom. Sometimes they do, like they get forced into it when they continue to be unjust, but often they don't. And so what I say to people is this. If you are faced with a denial of a claim or a cutoff of your benefits, you got to speak with us immediately because we know how to deal with them, we know the pressure points, and we know how to get them to the table to pay you what you're owed. Period, full stop.
We'll take a short break, and as mentioned off the top, 3 things you must do when dealing with an insurance adjuster. That is on the way. In the meantime, here's the number, 1-855-821-5900. Email help@disabilityrights.ca as well. This is the Disability Law Show. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. Okay, welcome back. Thank you so much for hanging in. As we get to our topic for this show, it is 3 things you always need to do when dealing with an insurance adjuster. If you haven't been through this before, keep a mental note of what we talk about over the next few minutes. Number 1, Sivan, is this. Ask for a copy of your LTD policy and go through it.
Yeah, and you know, John, I can tell you that most people, when you tell them go through a policy, whether it's a home insurance policy, I know. I get it completely. I agree with you. Here's the thing. You don't want to go through it, fine, but at least ask for it. You have a right to get it. Okay, you have. In every province where we operate, Ontario, BC, and Alberta, where we have lawyers, we've checked the legislation. You have a right to get it. In fact, on our website, ltdfaq.ca, that free website we created, there is a memo that if you go to it, it talks about that, and it tells you which provisions and which legislation in the province gives you that right to get the copy of the policy.
Wow.
And if the insurer doesn't give it to you, contact the ombudsperson because they have to give it to you. Why do you need that policy?
Right.
Because that policy governs the relationship between you and the insurance company. If the insurance company says to you, hey, John, we want you to jump 500 times in order to get this money, you can say to them, I've looked through the policy and it doesn't say anything about that. Show me the provision where it says I got to jump 500 times. Insurance says you got to go to this particular clinic for treatments. No problem, insurance company. Show me where that provision says in my insurance policy that I got to do it. So the relationship between you and the insurance company when it comes to long-term disability is a contractual relationship. That policy, that document contains all of your obligations to the insurance company and the insurance company's corresponding obligations to you. So you must ask for your policy from the outset and don't let them give you the runaround. Get a copy of it.
I would imagine for the average person like myself or anybody watching this show that, you know, they can get the policy. Sure, they should probably give it a brief read through. There's going to be a lot of stuff in there they're not going to understand. Might have like a bird's eye view generally of what's going on. So the second one they should do, according to this, is ask the adjuster to explain anything they don't understand in reference to that policy, right?
Yes, exactly. And that's key because sometimes people contact us and say, you know, John or Sivan, I no idea why I'm getting paid what I'm getting paid. I thought it was supposed to be 66% of my income. How are they calculating? What about overtime, bonuses, all that kind of stuff? The policy should stipulate exactly what the calculation is. And the insurance company, the adjuster, should be able to explain that to you. But it's not just about the payments, it's anything that is in the policy. Again, if they tell you to do something that raises a red flag for you, tell them, okay, well, show me where in the policy it says that. And if you read the provision and it doesn't make sense to you, okay, adjuster, explain to me what exactly, where does it say that and what does that provision mean? You know, something else you should understand is that insurance contracts they must clearly state any exceptions. They must be clear in their intent. Because if the insurance company is pointing to a provision in the policy, I'm going to get a little technical here. If they're pointing to a provision in the policy that says something that they say it says, but when you read it, it actually says something different to you, and there are two logical explanations, meaning you can interpret that provision in two different ways, reasonable ways, one your way, one the insurance company's way. If this ever went to court, which again it would not, but if it did, the court is going to choose your way. Because the insurance company is the one that drafted this policy. So any ambiguity is interpreted against them. It's actually a doctrine of contract interpretation. My point is this, okay, without getting again into the technicalities too much. If there is a provision in your policy or there's a concept you don't understand, ask the adjuster, your adjuster, to explain it to you. They have an obligation to do so, and if they give you the runaround, go to the manager. You have a right to understand what the contract says.
In your experience, when they say things, you know, Sivan, you must do this, this, and this, and you're like, well, point to me where it says I have to do that in the policy. Do you find insurance companies try to do that all the time?
100%. Let me give you an example.
Okay.
Example. We use this all the time, actually, in different contexts. Somebody calls me and says, insurance company's telling me to go to this clinic for treatments.
Right.
I tell them, okay, tell the insurance company to tell you where in the policy it says you got to go to that clinic. They call me up 2 days later and say, Sivan, I spoke with my adjuster. They showed me the provision. The provision says I have to be engaged in reasonable treatments. I said, okay, I understand that. I agree with that. But where does it say you got to go to that clinic? Oh, it doesn't say that. But the adjuster said that this provision means that. No, it can't mean that. The provision says you must get reasonable treatments. If the provision said you must go to this clinic or to a clinic we tell you to go to, that's a different story. You see, they often read something into these provisions that is not there. They can't do that.
Which brings about our third point. Dovetails nicely. Thanks for doing that for me, pal. That is confirm all conversations with your adjuster in writing, right?
Yes, and that applies across the board. Look, you got to make sure that you confirm these. I can tell you that adjusters, whether it's intentional or unintentional, in many cases I can tell you it's intentional because I've cross-examined them and I can tell you that they've admitted that they've cherry-picked information. You can be on the phone with them and they say, hey John, how are you doing today? Oh, I'm doing well today. Maybe it's the one day out of the year you're doing semi-okay. In their notes, John says he's doing okay. And then a subsequent note, clearly that's an improvement. Right, that's from the adjuster. So my point is though, after the discussion, after the phone call, if you've had that phone call with the adjuster, that same day, email the adjuster, not a long email, but here's a confirmation of what was said. Don't use adjectives, just be very factual. Here's what was said, what I said, what you said, just confirming the conversation. I don't care if they respond to you or not.
No.
I care that you've sent that to them. Now there is a record that's essentially contemporaneous with the event. It's not like a week or a month later. if at some point down the road we have to take on this insurance company and fight them and there is a discrepancy on what was said, guess what? We have everything you confirmed in writing to the adjuster. That's very powerful, very powerful. I know it's a headache to do. I know it's an extra step, but do it. Trust me, you want to confirm these things in writing with the adjuster.
You know, you mentioned about taking, contemporaneous notes and so on and so forth. You often talk about this one time, I think you were dealing with an adjuster, and there was a doctor's note which was hieroglyphics. Nobody could understand this thing, and they made a judgment based on that, and you kind of cornered them on that, didn't you?
Yeah, absolutely. I mean, these adjusters, you have to understand, these adjusters, they're not, for the most part, I can tell you, not bad people. I've dealt with them. Some of them are friends, actually.
Yep, for sure.
I've developed respect, especially more senior adjusters that I've known for a long time in some insurance companies. They're not bad people, but they have a job to do. And their job is to work for their overlords, the insurance companies. And the insurance companies are there to make money. And so what many of these adjusters do, what their purpose is really, is to save the insurance company money. And so this one case you're referring to, it's a case, actually it wasn't my case, it was Albert's case, one of the lawyers on my team, where he actually cross-examined at a discovery the adjuster, where the adjuster said, yeah, I admit it, said, before cutting off the individual, the benefits, I reviewed all the medical information and documentation we had. And Albert says, okay, everything, yes? Before you made the decision to cut off, yes. And your decision to cut off was based on all of the medical documentation, right? Nothing was missing, correct. Okay, he pulls out the family doctor's records. Can't understand anything in there, okay? It's like one of the literally hieroglyphics, worse than hieroglyphics. John, I am telling you, he puts it to the adjuster and says, can you read this? No. Did you have it transcribed? No. Did you ask the doctor to transcribe it to provide a report? No. Did you read these? Did you understand those notes before you made the decision to cut off? No.
It's getting hot in here.
Man, what I heard subsequently is, the lawyer for the insurance company was uncomfortable. It's one of those movie moments.
Yeah.
Do you think that case settled quickly?
Just a little.
Yeah. Very quickly.
We'll take a short break. More to come. MyDisabilityQuestions.com. That's a website I will direct you to anytime to ask some questions, and that's where we're going to go after a short break. 1-855-821-5900. The number. Email help@disabilityrights.ca. Coming right back. Stick around. People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. Okay, welcome back. Disability Law Show. A few minutes to go. Thank you so much for hanging in there. You can reach out anytime to Sivan and his team. I'll give you the phone number first, 1-855-821-5900. Email is help@disabilityrights.ca. But now we go to mydisabilityquestions.com, free and anonymous website to ask your disability questions. It's also searchable, so your question may already be in there, asked by someone else. Read the reply. If it works, off you go. If not, leave your question there and it will get answered rather quickly, I might add. Philip is up next. Says, I've been on LTD for almost 2 years, but was recently given a return to work date and plan by my insurer. My doctors don't believe I am ready and that I need extensive physiotherapy before I'm able to function properly. I don't understand how the insurer could push me to return before I'm ready. What should I do?
Philip, this is something that happens quite often. It's called a work hardening program, return to work program. And insurance companies, remember, they're there for one purpose only, which is to make money, not to save your butt on a rainy day the way they advertise on TV and radio and paper. They're there to make money. And so one of the ways they do it is by trying to get people back to work, which on its face is actually admirable. If they give you all the support you need, that's great. Yeah. We want people not to be on LTD, 100%. But sometimes they take that to the next level. They tell you to do something, or they impose a timeline on you that does not correspond with the reality and certainly does not jive with what your doctors are saying. And in this case, for Philip, obviously his doctors don't believe that he's ready. So what do you do in a situation like this? I'll tell you what you do. You go to your doctors, Philip, and you make sure that you explain to them what the insurance company is doing, and you get their advice. If the doctor believes this is premature and here's why, the doctors must provide a letter, or should provide a letter or a report explaining why this is not the right time. The doctor is not going to say that you're never going to be able to go back to work. The doctor may say, let's reassess in 6 months or a year or whatever it is. But as long as you have a letter that says it's not the right time, it's my medical recommendation that Philip does not go back, as per what the insurance company says, but, we reassess in 6 months or a year, you give that then to your adjuster, and you tell the adjuster, I'm going to follow my doctor's recommendations. It's my doctor. And if the insurance company is obtuse and despite that says, no, if you don't comply, we're going to cut you off, you contact us immediately because we'll intervene. We may not be able to avoid the cutoff, but I'll tell you what, we're going to hit the insurance company extremely hard with a legal claim. And we're going to claim punitive damages and aggravated because the insurance company does not have the best interest of the claimant at heart. And it should. Insurance companies are under a fiduciary obligation to treat claimants and insured individuals fairly and justly. What that means is it's almost like a sacred duty that they have. And courts have come down hard on insurance companies for not doing that. So Philip, you need to go to your doctors right now, get the right reports, give it to the adjuster, tell the adjuster you're going to follow your doctor's recommendation. You're not ready to go back to work. If there are any problems, you let us know, okay? And then we will help you.
Quick email right here now, Sivan, again, help@disabilityrights.ca is that address. Kim, it's a short one, says, do I have the right to ask my insurance company if they are conducting surveillance on me? How about that?
Surveillance. 100%, Kim, you have the right to ask.
That's it.
They may not give it to you. They may not tell you, right? Listen, insurance companies conduct surveillance. Yeah. When I worked for insurance companies, I ordered surveillance as the lawyer protecting insurance companies. Most surveillance insurance companies get is useless. The only time it's effective is if the claimant is lying. And it's happened. Mm-hmm. If you say you have a back injury, you can't sit or walk for more than 30 seconds, and they have you on tape on the weekend playing volleyball for an hour, or playing soccer, or dancing at a party for God knows. Well, that's a problem. Yeah. And frankly, you should be caught, right? There is fraud. There are people who are trying to game the system. But the reality is that for most people, especially people who contact us who understand that we don't deal with this kind of nonsense, if your claim is legitimate, don't worry about surveillance. You can ask. They're not going to give it to you. They're certainly not going to. They're not going to admit and tell you. Sure. Some people are suspicious because they see somebody outside their house, and we can deal with it. By the way, we have a memo on surveillance on our website ltdfaq.ca that answers the most common questions about this topic. But let me just jump to the end here. If you are cut off, LTD, because of surveillance, contact us immediately because, John, we've had time and time again where we've had people cut off wrongly because they say that the surveillance shows that they're doing something that they're not actually doing and that it shows that they're not disabled when the opposite is true. And we resolve these cases. Insurance companies end up paying. So don't be afraid. If you are surveilled, if your cut-off benefits are denied because of surveillance, we can probably help you.
They want to get something out of it, I imagine it's not cheap, right?
Oh, 100%. You know how much it costs? It's easily $1,000 a day, if not more, to get a private investigator. By the way, for anyone out there who thinks there's a private investigator from your insurance company that's outside your house 365 days a year, that doesn't happen. Insurance companies will do it for like 3 days at a time, 4 days,
that's enough.
Once in a while. It's very expensive. They just don't.
Wrapped up for another day. Thank you so much for tuning in. To reach out now, 1-855-821-5900, help@disabilityrights.ca, and also mydisabilityquestions.com. Thank you so much. We'll catch you next time. Disability Law Show.